Con las palabras del magistrado Eduardo Valdés Escoferi, concluye la etapa formal de esta ceremonia para dar paso a la conferencia magistral a cargo de nuestro invitado internacional. Sir Jeffrey JOWELL posee una extensa hoja de vida y yo me permito extraer de ella lo que considero es de relevancia para conocimiento de todo el auditorio. Sir Jeffrey JOWELL, condecorado en el año 2011 por Su Majestad Elizabeth II, por sus servicios en la promoción de los derechos humanos, la democracia y el Estado de Derecho en Europa. Sir Jeffrey JOWELL combina una exitosa práctica legal ante los tribunales de justicia con una prolífica carrera académica. En octubre del año 2010 se convirtió en el director inaugural del Centro Bingham para la promoción del Estado de Derecho. Es también profesor emérito de Derecho Público del University College London, entidad de la cual ha sido decano. En el año 2012, la prestigiosa publicación The Times Law incluyó a Sir Jeffrey JOWELL como parte del listado de los 100 juristas más influyentes a nivel global, citándolo como una de las más destacadas autoridades internacionales en las áreas de derecho público, derecho constitucional y derecho administrativo. En el ámbito profesional, Sir Jeffrey JOWELL incluye la asesoría técnica en la redacción de constituciones nacionales, la relación entre el Reino Unido y sus dependencias territoriales y el diseño y aplicación de legislación relativa al Ombudsman. Sir Jeffrey se ha desempeñado como consultor asesor en la modernización constitucional de países tales como Sudáfrica, Bosnia, Serbia y Montenegro, Luxemburgo y las Islas Caimán. Del año 2000 al año 2011 se desempeñó como representante del gobierno británico ante la Comisión de Venecia, del Consejo de Europa, especializada en la consolidación de la democracia a través del derecho, brindando asesoría a miembros de la Unión Europea en materia constitucional y de derecho público. La obra académica de Sir Jeffrey es de tal relevancia que sus textos son continuamente citados por cortes de justicia dentro y fuera del Reino Unido. Sir Jeffrey es también mediador acreditado del Centro para la Resolución Alternativa de Disputas, ubicado en Londres. Posee además doctorados honoris causa de las universidades de Atenas, Ciudad del Cabo y París. Señores todos, con el título Revisión Judicial y Separación de Poderes, una perspectiva comparada, me permito presentar la conferencia magistral de Sir Jeffrey JOWELL.
I regard it as a tremendous honor and privilege to be here in this country. And also, it has been a great pleasure. I've only been here a few days, but I've been received so warmly that I just want to thank you for that. I read a lot about Panama before coming here, but nothing prepared me for the impact of this magnificent city or the beauty of its surrounding areas. It seems absolutely clear from what I can gather and from all the construction activity that there is great hope for the future of this country. It is a palpable feeling that one has, that it is expected and ripe for development as a great center of the future, commercial, financial, and also cultural, on a world-class scale. That is simply the impression I have. And speaking to people and looking around, that is the kind of message that is conveyed to a newcomer looking on it with new eyes. But history shows that to achieve that kind of status on a sustainable basis, a country needs a very, very solid infrastructure. And this is the question I am addressing today. The infrastructure of law, the rule of law, is absolutely essential if this kind of development is to be maintained. And I'm not here to prescribe what you should do, what direction you should take, or any other solutions. I'm simply presenting to you some comparative examples through my experience and from what I have seen elsewhere to indicate some of the ways in which sustainable legal institutions have been achieved elsewhere and have not been achieved elsewhere because they ultimately lacked the legal capital and sustainable rule of law structure, infrastructure. So the subject today is the rule of law and constitutional evolution. And I'm going to particularly look at the questions of judicial review and the separation of powers dealing particularly with the independence of the judiciary from other branches of government. So let me start with a brief introduction to rule of law. It used to be thought that the rule of law was a very vague concept, but a number of international bodies have been looking at that issue. Ban Ki-moon, the Secretary General of the United Nations, has recently sought to make the rule of law one of the very important platforms of the new post-2015 development program of the United Nations, which is succeeding the Millennium Development Program, which said not much about the rule of law, but he wants to introduce it. Other bodies in Europe, elsewhere, are looking to see whether they can give some practical content to the rule of law. And what we're finding is that the rule of law is a universal concept. It's not only for developed countries or for the West, the North, but it is for everyone, because it speaks to the control, the necessary control of government power, and that every individual should be treated with equal dignity. And these are universal concepts. We were helped in this, certainly in the English-speaking world, by a recent book by certainly the greatest British judge of our generation and before even, Tom Bingham. He died 3 years ago. He wrote this book, The Rule of Law, which I think is now being translated into many subjects. I direct, as has been said, the Bingham Center for the Rule of Law in his name, which is an international body. We're not only doing work in the United Kingdom, but in Myanmar, in Burma, in the Arab Spring, and elsewhere, in Africa, and so on. And the virtue of this book is that it sets out the rule of law very simply and as a very practical concept. It's not that theoretical. It's easy for everyone to understand. The rule of law occupies space that is somewhat different from democracy, but it is the spine, the center of democracy. it occupies space that is somewhat similar to human rights. It's not the same as human rights, but it gives access to all people's rights, including their human rights, the civil rights as well. And even in countries that rule by law, rather than through the rule of law, which is a richer concept, even there, if you do want to respect people's equal dignity, you must have the rule of law and not merely rule by law. This audience is highly sophisticated in legal matters, and I needn't outline all the elements of the rule of law, but you will know that laws must be certain and predictable. Discretionary power is permitted, but it must be controlled. And it seems to me that Panama leads no lessons in that aspect of rule of law. And of course, the second aspect of the rule of law is that law must be equally applied. The rich to the poor, to the powerful, and the marginalized. So there's a strong notion not only of legal certainty in the rule of law, but also of equality, equal application of the law. And of course, in many countries, the rule of law is distorted if there is the opportunity for corruption, because that gives access to the law to those who can afford to pay a price for it. And then we come to the elements of the rule of law that I will now speak about, which is access to justice. The opportunity, and this is so crucial, the opportunity to challenge decisions made about you, normally by officials, but it could be by other private institutions as well. And to challenge them through a system of courts. There may be other ways of challenge, ombudsman and so on, but through a system of courts. And in doing so, to be able to receive a fair trial, due process. And essential to that fair trial is, of course, the independence of the judges, of what I call judges. I know you call them at the higher level magistrado. We call magistrates our lower judges and judges at the higher level, so the interpreters will know that when I talk about judges, I mean also your very distinguished magistrates, who I have had the honor of meeting some of them during my short stay here. So absolutely essential to the rule of law, then, is access to the courts through judicial review. And that brings me to the first part of my presentation, judicial review. It's important because in any country governed by the rule of law, every person who is a party to the dispute must believe that his case will be decided, first of all, can be decided, and secondly, will be decided in accordance with the merits of his argument, rather than what other branches of government might think, or the loyalty of the judge to a particular personal ideology, or the bias of the judge to a particular party, or even to other judges in the court. They must be independent from one another. So the opportunity fairly to challenge a decision in a court of law is what we seek to achieve. Now, let me turn first of all to how you do this through judicial review. And I have been looking, again in a very superficial way, thank you, at the judicial review in this country, the various procedures, the third chamber of your Supreme Court procedures, the amparo procedure, constitutional review. And what I can say about that is that it is very understandable and very familiar to even a lawyer from a country that does not have a codified constitution. We don't have a written constitution in the United Kingdom. It seems strange, but we do have constitutional principles, and we do have various statutes and understandings that allow us to have very much the same procedures as you do, and even these days, countries like France or Egypt, which is based on the French system, and other countries that used to in past have very different systems. But there has been a convergence, both of procedures and particularly of standards. So in most countries in the world, the government can now be challenged on the grounds that they are acting outside the lawful powers that were conferred on the decision maker, on the grounds that they have not acted in accordance with what we call fairness and what the fair procedures and what the Americans called due process, or that the decision falls foul of a number of substantive points. There isn't sufficient evidence to make that decision. It was not reasonable. It was disproportionate, and so on. And so on. So those are the standards of judicial review. What about the procedures? In the United Kingdom, and this may be of interest, we allow very broad standing to sue. If that doesn't translate, I'm talking about the opportunity for anybody, even if they don't have a direct interest, a property interest, for example, in the case, to come to the court, access to the court. We call it standing to sue, locus standi. It's very broad. But there is a process of filtering the application. We have a procedure called the application for judicial review. An individual wanting to take on a case against the government in particular first has to get permission to proceed. And permission will only be given if there is a realistic possibility of winning the case. If there is a very strong case. Not every case goes through that door, is permitted to go through the door. There is a filter. And then the procedure for that kind of action, because it entails government and ought to be decided quickly, without undue delay, must be brought within a certain time, normally 3 months. And the remedies are either to strike down the decision, to declare it invalid, or to order the body to do its duty by law. Our courts, and this may be a difference, I think it is a difference, do not have the opportunity to rewrite the decision. So that's basically the judicial review procedure. I should say that 30 years ago, that procedure virtually had no cases in the United Kingdom. When a law, a statute, gave power to an official, whether the executive or a municipal body or whatever, to act with broad discretionary powers as they think fit in the public interest, the courts were very reluctant to cut down that discretion because we live by the concept of the sovereignty of Parliament. But over the years, the courts no longer adopt that position. Through the judge-make law that we have, the common law, the courts have decided that it is an essential part of any democratic society based on the rule of law, that the individual ought to be able to challenge governmental powers and that those powers are assumed to exist within the constitutional principle of the rule of law, even though we don't have a written, a codified constitution. And that's the way the judges developed this and allowed individuals to challenge even the broadest of discretion by specific standards, those standards that I've mentioned. And those standards, we're looking around the world now, seem to be universal standards of good administration. How interesting it was that when South Africa adopted a new constitution in 1994, it regarded the right to administrative justice, the right to challenge an administrative act, as a constitutional right written into its constitution. The right to act, the duty on all administrations to act lawfully and reasonably and fairly, and to give reasons for their decision. And that provision has swept through the African continent and is even now part, the right to good administration is part of the Charter of Rights of the European Union. So that was an export from Africa. There's another export that I'm going to talk about in a moment. Just to complete the picture in the United Kingdom, the same procedure that I mentioned, the application for judicial review, is also used to challenge decisions on the basis of the failure to come up to the standards of human rights. Now again, we don't have human rights in our Constitution, but since 1998, we have incorporated the European Convention for Human Rights into United Kingdom law. And they contain rights very similar to the Inter-American Courts Convention, and indeed many of the constitutional provisions in Panama on human rights. So through that procedure, we also now decide questions and even are able to review laws, not only administrative acts, review statutes of Parliament, for example, very similar to the case which the Vice President just mentioned. Is there a conflict between free speech and the equity of electoral choice? And those questions would be decided in accordance with the concept of proportionality. The only difference, by the way, is that in the United Kingdom, the courts are not able to invalidate, to strike down the laws. All they can do is declare them to be incompatible with the European Convention. And then it's up to government to decide what to do. But as a matter of convention, not law, it has always agreed to implement the decision of our higher courts. There's one case outstanding at the moment where it may not do that. It's a case where it has been held by the European Court that a ban on the voting on the part of prisoners should be permitted by the United Kingdom, which it is not now. So that's judicial review, and it's an essential key part of the rule of law in that it allows fair challenge and proper challenge, particularly to decisions by the government, including the executive, the Prime Minister, the President, whoever it might be. Let me now move to the other key question of independence of the judiciary, and that is, what method of judicial appointment is most likely to achieve independence of the judiciary? And another question that I'll touch on fairly lightly after that is, what about these independent judges? They are not elected normally by the people. To what extent should they be held accountable to the Constitution? Judges accountable to the Constitution. So there are a number of models. There are 6 models for the appointment of judges across the world. The first is election by the people. And this is used, as you will know, in many of the states of the United States, but not many other places. People, candidates for judicial office, will raise money themselves, and then they will campaign as if they were politicians for office, and they will take office. They will not deal with hugely important matters, but some. Secondly, there's the model of appointment by the executive alone. This could be the Prime Minister or the President alone, without any other body. And this used to be the system in the United Kingdom. Up until 2005, the United Kingdom Lord Chancellor, he's really our Minister of Justice. It was a peculiar, very British position. The Lord Chancellor appointed all judges in the United Kingdom. He would take what was called secret soundings, and then he would come up to a person with a tap on the shoulder, it was always said, and say, "Would you be a judge?" Now, I'll come to that later, but I'll just say for the moment, that was the method up until 2005. I should also say that our Lord Chancellor then, not now, also sometimes acted as a judge, the top of the Supreme Court. Not very often, because he was a busy person being Minister of Justice, but he was entitled to sit as a judge, and sometimes did. And he also, of course, came to cabinet as a member of cabinet. So no separation of powers there. But I should say, I don't normally defend my country blindly, but the British system, even with executive appointment at that time, I think did produce one of the most independent judiciaries in the world, but that was because there were other cultural reasons why this should be so. The third method of appointment is like here. The executive, the president and cabinet, nominating, and another branch of government, the legislature, the assembly, confirming the appointment, as in the United States. And then there's the fourth method, which is the appointment by the legislature alone. Not for all courts, perhaps, but as in Germany, it's both houses of the German legislature, of the German parliament, by a 2/3 majority, with agreement of the 2 main parties, and they do have 2 stable main parties there, elect the members of their constitutional court. So that's election by the legislature. And it is felt there that that is a court where it is more political than other courts, and therefore the legislature ought to have a role in that. Only the legislature, not the executive, and no one else. Between number 3 and 4, there is a mixed system, which is the system in Japan, in some East European countries, and in South Korea, where the president nominates 1/3 of the members, 1/3 are nominated by the Supreme Court itself, and 1/3 by the legislature, by parliament. So that is what I'll call the Japanese mixed model of different branches. The fifth model is where judges appoint their own members, at least in certain courts. You have that. You have the higher and the lower courts. You have the judges above appointing the judges on the lower courts. But in India, the Supreme Court is effectively nominated by the decision of the judges of the Supreme Court. And Israel has a similar system. They feel very much that judges should nominate judges for the top court. There should not be anything to do with the electorate or the legislature or the executive. Officially, in all these cases, it is normally the head of state who actually does the appointing. The person who's going to be a judge will go to the president and get the judge's orders. But it is those other bodies that, in practice, carry out the selection or election. And then finally, let me come to the newer model, and a model that is gaining ground very rapidly on those other methods. And that is the judicial appointment commissions. You will have an independent commission appointing the judges, by which, again, I mean the magistrates, usually the higher court, but many other courts as well. Because of our problems in the United Kingdom with the appearance of lack of independence of the appointment of the Lord Chancellor, and I say again the appearance, in practice I think our judges were independent, but because of the matter of appearance, it was decided to move to a system of judicial appointment commissions. They can be composed in different ways. In South Africa, it was decided to have an independent commission to appoint all their judges. And that commission also dealt with discipline and promotion of judges. And there you have the majority of the members are members drawn from Parliament. There are other countries where the majority of the members are people who are not lawyers at all. Majority. There will be lawyers on it, there'll be judges on it, but the majority are people who are looking at different sort of qualities. Is this kind of person accessible? Does he understand ordinary people? That kind of thing. And in the United Kingdom, the model was that there should be a majority of lawyers on the Judicial Appointment Commission. It is chaired by a non-lawyer, but it has a majority of lawyers on the commission. And that is the same model as in the new Iraqi constitution and in a number of new Caribbean overseas territories such as Cayman Islands and so on. They've got this way of doing things. Now, you may be asking yourself, how can you get an independent commission? Who appoints the commission? Is it the president? In which case, maybe it wouldn't be that independent. But the way it was done to overcome this in the UK and in other countries was to do it this way. It will be the judges who appoint the judicial members. Magistrates appoint the magistrates. A law professor will be appointed by the law professors. And so on. So each body involved will appoint their own people, and thus the body will be independent. This has greatly changed the whole nature of the judiciary, of the notion of judicial appointments in the United Kingdom, because people now have to apply to be a judge. A lot of very senior lawyers were not initially very happy about this. People would know they've applied, they will know if they don't get the job, they may be humiliated, but it is kept fairly quiet and secret, and it is done, again, in a way that is very independent. If the commission finds that they know the person, that they have received favors from them, that there is an association with them, they're members of their family or friends, the commission member will have to stand down. And then they go through a checklist ticking the boxes of various qualities that are published, such as analytical ability, such as accessibility, such as efficiency. There might be something, you want judges who actually write their judgments quickly and in time, and so on and so on. And there is an attempt also, under the statute, to get diversity, to have more women and members of minorities on our bench. That is an aspiration that they take into account, although merit, ability, is the main factor that they consider. So that is the way that judges are appointed in the UK and in many other countries in the British Commonwealth. It is becoming increasingly common for this method to happen. In the Commonwealth, which is no longer called the British Commonwealth, but the Commonwealth, whereas just 5 or 6 years ago, about 20% or even less of the countries had judicial appointment commissions, and 80% of judges were appointed by the executive. Now it's virtually the other way around. We're all moving to a more independent method of appointment. Now, very quickly, what are the advantages and disadvantages of each of these systems? Well, dealing with appointment by the executive, or the executive with other branches, or with the legislature, the disadvantages are obvious. Namely, that the judges, the magistrates, will be seen, even if they are not, they may be seen as agents of the person who appointed them, of the political party in power, of the particular president or prime minister. They will be seen, there will be that taint against them. There may be even pressures for them to act in accordance with the will of the particular political party. And we saw in the United States, in particular, what problems this caused for the integrity of the United States system in the case of Bush v. Gore. Do you remember? Mr. Bush stood for election for president against Mr. Gore. It wasn't quite sure, particularly because of the Florida system, who had won. And the matter went to the Supreme Court. The Supreme Court decided that those who had been appointed by Democrats said Mr. Gore was right. Those who were appointed by Republicans said Mr. Bush was right. So Mr. Bush won the election. I was in a meeting in Europe, in Central Europe, just after this decision took place, and an American law professor stood up to try and defend the system, and a professor from Yugoslavia stood up and said to the American, "You're always trying to get us to adopt your ways, your democratic ways. But why should we do this in future? If your judges, who you are telling us in the former Soviet Union should be completely independent from politics, if your judges just vote in this important case, on this important electoral matter, simply for the party who nominated them to the court." So that is the problem, as you may well know, with that kind of decision. Judges appointing judges, yes, perhaps at lower levels, but the top courts, certainly the United Kingdom rejected that model on the grounds that you might get a certain kind of self-perpetuation, a cloning aspect, that you'll get like people being appointed, particularly at a time in the United Kingdom which is much more diverse now than it was in the past, when we wanted more people from different backgrounds to get onto the court, and it was felt that judges were unlikely to move in that direction. And what about the appointments commissions? Well, I think I've said enough about them. It really depends to what extent the body is truly independent. It changes the whole nature of judicial appointments, but it does send out a very strong signal. And perhaps the Spanish Judicial Commission is probably the best example of this, where it has revolutionized the independence of the judiciary, and that is a model well worth looking at. Very briefly then on the question of the accountability of judges. Here they are. They're not elected. They're simply appointed. And what can be done to ensure that they are accountable? In what way should they be made accountable? Maybe they shouldn't be made accountable to the public, but only to the law and to the to the Constitution. But if we look at it, judges are more accountable in everything they do and in all their procedures than most other officials in our society. Every case comes to them with one side claiming one thing and another another. So there are two parties there. Where their decisions are reasoned, they have to account for themselves and show why they decided in the way they do, possibly in many, many pages. So that's another form of accountability. These decisions are often published into law reports where academics and others can pore over them and criticize them if necessary. The courts are organized by an organized legal profession, and the Bar Association usually seeks integrity and independence in members of the bar as well. It doesn't always work, but at least there's that added attempt to structure independence. In many cases, not the top courts, but in the lower courts, there's an opportunity of an appeal to a higher court. So that's a form of check on the discretion of the judges. And of course, there's the possibility of disciplinary measures where the judge acts outrageously or has been held to take a bribe and so on. We could take that kind of accountability even further if we wished. In Hong Kong, now this is the kind of place I was thinking of a few years back when I looked at Panama, and early on in the days of its development, it was, I hope you don't take that analogy amiss, but I certainly find it a very dynamic and interesting place now. In earlier days, it was rife with corruption at all levels, including the lower judiciary. The top judiciary, there have usually been people of greatest integrity and ability. But they passed a law that provided that anybody whose bank account suddenly increases is presumed to have taken a bribe unless he proves otherwise. And miraculously, almost overnight, this reduced the amount of corruption in that city. And there were other measures, which I have no time to go into now, to strengthen the rule of law. Another method of accountability, which is being brought in the United Kingdom, is what we call peer review, by which I mean, for the benefit of the interpreter, review by other judges. So a group of judges will, particularly the Chief Justice, will constantly will set targets for the number of cases that go through the courts, through time that it takes to write judgments, the time that it takes to keep litigants waiting. So that's another form of accountability, and those reviews are published and open to the public. Finally, on a recent visit to Brazil, I discovered another very impressive method of accountability. In the basement of the Supreme Court building in Brasilia, a television station broadcasts for most of the day about cases as they are decided, with summaries in very accessible language to the ordinary person, and then often having debates by experts analyzing the results. School children are brought in to discuss the cases. This program is deeply popular. It has an audience of millions, including in schools, and provides both a means of communication about law and of accountability for the process and for the substance of the decisions. Our Chief Justice, the Chief Justice of the United Kingdom, recently, I told him about this, and he went to Brazil, and he was deeply impressed with that method. And as a result, we have introduced a television into some of our courts, and also discussions with experts about legal cases available to the whole population so that they could learn that law and the rule of law is not only for lawyers, but for the entire population. Thank you very much indeed.